Ladies and gentlemen, gentlemen and ladies, ladies and gents, we got a little bit of snafu that we're working with. We're going to just sit up here and save our file, and we're going to put, no, let's do it this way. We're going to call it all save, okay? That's going to be the new music playing list. Now, we got a little bit of Mary J, and she's talking about how somebody needs to not work that. All right, the document you see in the background, let's highlight it because we're not worried about the little notes, because I don't want you to focus on the notes. As you see, there's a 1997 security warranty deed, blah, blah, blah. This is a deed of trust. Pay attention. Waiver of borrower's rights. Each one of you have this in your mortgage agreement. Pay attention to what I'm about to say, because some of y'all don't know right from wrong. You don't know left from right. You don't know what's a legal argument and what's not a legal argument. We got a lot to talk about, so put your hats on because we're about to go there. This video is going to be roughly about less than 10 minutes long, because we're only going to cover this document, and then we're going to move on and do another video right after that. Promise you I was going to do this video. This video is for you mortgage people, those of y'all who having mortgage problems. Pay attention, because I'm about to mention the style. And anyway, ladies and gentlemen, by execution of this paragraph, the grantor, you're the grantor of the agreement. You are the grantor of the agreement. You are the grantor of the agreement. There is something that's called truth in lending. Okay? You are the grantor of the agreement, and they announce it to you. They say you are the HNIC. Okay? So you're the grantor. You acknowledge the right to accelerate the debt. Well, there is no debt. Hold on. And the power of attorney given herein to the lender to sell your property by non-judicial foreclosure administrative process upon default by you, without any judicial hearing and without any notice other than the notice as required and given under the provisions herein. You waive any and all rights which you may have under the Constitution or the Constitution for your state. See, various provisions of Constitution for the several states. Okay, understand that's what you agreed to. Or by reason of or any other applicable law to notice and judicial hearing. Sorry, I got to find my mouse. Y'all can see my mouse, but I can't. To notice judicial hearing prior to the exercise of the lender by lender of any right or remedy herein provided to the lender, except such notice as is specifically required to be provided hereof, acknowledges that the grantor has read this deed and specifically this paragraph, and any and all questions regarding the legal effect of said deed and its provisions have been explained fully to the grantor, and the grantor has been afforded an opportunity to consult with counsel, because this is being done before an attorney. Hold on. Yeah, I knew it was going to do that. It's been doing that lately. Okay, anyway. Pay attention, ladies and gentlemen, so that you get what's going on. They tell you have the right to consult with counsel of the grantor's choice prior to executing this deed. What choice do you have? They say if you don't sign it, if you don't waive your rights, you're not going to get the loan. Acknowledges that all waivers of the aforesaid rights of the grantor have been made knowingly, intentionally, and willingly by the grantor as part of the bargain for loan transaction. No, you weren't bargaining. They didn't give you a choice. They said if you didn't sign this, you weren't going to get the loan. Agree that the provisions hereof are incorporated into and made part of the security deed read and agreed to by grantor. The grantor signs it. Hold on. That signature right here. That signature right here. See, that signature. Who's that the signature of? Watch this. Before the undersigned, a testing officer personally appeared, and the undersigned closing attorney, who having been fully sworn according to law, states under oath the following. Who's the attorney? Where's the attorney's name? Anybody see a name for an attorney? Attorney name? No. See? Who is this? Where's the attorney? What's the name? Interesting, ain't it? This happens every day, people. Every day. Every day. Every day. Need you all to pay attention. This is in your document. Truth in lending. Remember, they cannot make the fact that you waive your rights a condition of your getting a loan. You have a right to a loan. This is a federal loan. It is under federal law. The federal law says that you have the right to a loan. If you have a right to a loan, you don't have to surrender your rights in order to secure the loan. That is illegal. Don't ask me. You need to bring that up as your argument. Make them prove that they can make you, force you, waive your rights, surrender your rights, give up your rights. They cannot. Not today, not tomorrow, not to maybe, not no day. All right, ladies and gentlemen, we got Casey and JoJo singing to us right now. We're going to do a little bit of shuffle after that Casey and JoJo song, but we're going to let y'all go because we just wanted to prove to y'all that you've waived your rights, and it's all on you because you are the one allowing them to foreclose on your house. An argument for saving your home is the fact that they failed to give you a remedy. They said that if you did not waive your rights, you could not get the loan. By doing that, they committed extortion. Why? Because in the United States, everyone has the right to acquire a home. That's why they're called the borrower. That's why this is associated with the federal government. The federal government cannot require that any of the so-called federal citizens, U.S. citizens, state citizens, any other citizen is required to waive their constitutional rights in order to obtain a loan for a home when everybody in the United States has the right to contract and the right, pay attention, to own a home, the right to property. By making it mandatory that you waive your right, pay attention, based on said review with an explanation of the borrower to the borrower, it is my opinion that the borrower knowingly, intentionally, and willingly executed this waiver of the borrower's constitutional rights to notice and judicial hearing prior to any non-judicial foreclosure. That's why they're called non-judicial states, because you waive your right to a hearing prior to having your property taken away from you. Supreme Court that says that an individual has the right to a hearing prior to being subjected to any substantial deprivation of rights. Told you guys about that already. Requires that we inform you that if you fail to meet any conditions or terms of this document that you sign in connection with obtaining a mortgage loan, you may lose the property that serves as collateral for the mortgage loan through foreclosure. Ladies and gentlemen, the property cannot serve as collateral for the loan. So even in this, it's a violation of the individual's rights. Okay? So there you go. There's that video. We're going to do Brian McKnight some other day. We're going to put a little stop to this, let you all get back to y'all days, y'all lives, y'all days. So there you go, ladies and gentlemen. There you have it. Have a good day. Have a good life. Have a good night. Under 10 minutes.